Hey, Rick McBride here with your Property Masters and 5 minutes of free time. Today we're going to review the exciting topic of the Florida FAR as-is residential contract. This nice monster of an agreement. I like to tell the story before I have somebody sign this contract about when I started in the business. We had one paper, it was on legal size paper at least, and it had carbon copies, and you filled in the blanks, and you drove it to one person and drove it to another, and they said how much they wanted to buy it for, and that was pretty much the end of the contract. It is now 12 pages long. They just came out with a new revision, which is why it's top of my mind to review it. And I like to say every word is in this piece of paper because somebody sued somebody over something. The contract we use most often is the Florida FAR as-is contract. There is another contract, but today we use mostly the as-is. It's called FAR because it is approved by the Florida Association of Realtors and the Florida Bar. So they both reviewed it, they've created it, and they said, hey, this is what we want you to use. It is issued to us by the Florida Realtors, and basically we are able to fill in the blanks, and that's all we're able to do because, and here's our caveat, we are not lawyers, so anything I say here is not advice. It is strictly my opinion and what I see of the contract. But not being lawyers, we can't change anything on the contract, nor can we give you advice on what you should put in your contract. However, at the top of it, it identifies the parties, obviously. And the property description. In a contract, you have to have both the address and the legal description of the property. I don't know if you've ever seen the legal description, but you'll never understand it. But people who, a surveyor is able to identify the property based on that, and you can find it in the court records. Next is personal property included in the contract. You generally don't want personal property in the contract. You want a separate agreement. Personal property is sold in a bill of sale. It is not sold in a real property agreement. However, some things are included not automatically, but are at least in the list of things included in the sale. And they are the range in the oven, the refrigerator, the dishwasher, disposal, ceiling fans, intercom, light fixtures, drapery rods, draperies, blinds, window treatments, smoke detector, garage door openers, security gate, and other access devices, and any storm or shutter panels. The reason that stuff's included is because it's usually unique to the property. You can't really take it from one property to the next, but it's still personal property, so it is included, and lenders have said, okay, we understand that. The reason you can't put personal property into a contract is because lenders won't lend on it. That's the main reason. There's another section here where you can exclude any items from the contract. So let's say you had a chandelier that's been in the family forever and you want to take it down, you can exclude that, and that's fine. Next is the most important part, the purchase price, and the initial deposit that you're going to put down, the escrow deposit, and then when you're going to make that deposit and who is holding that deposit. That is mandatory in the contract. Any financing that you're going to get, you identify, and then at the bottom you'll have the balance to close. You will have the date that you wrote this offer, as well as the date that the offer expires. So if you wrote this offer today and you only want it to be valid till tomorrow, then you write that into the contract. And also the closing date, the date you anticipate closing, that will be in there as well. There's a provision for when you can extend the closing date. There's a force majeure, which means hurricane, tornado, whatever, clause in there. And there's whether you're going to occupy the property. Also, does it have a tenant in it? You can check and identify that. And then Section 7 says, can you assign the contract to someone else? Typically we don't want to be able to assign, but you have the option to assign it. One of the most controversial clauses, and still not really clarified in this contract in my opinion, is the financing. You can check that you're going to pay cash or finance it. It doesn't mean you have to pay cash. You could still finance it. You're just not going to make it contingent on financing. So you can check if you're going to pay cash or finance the contract. Secondly, you identify what type of loan you're going to get: VA, FHA, USDA, conventional, whatever it is, the term, whether it's fixed or adjustable, and the length. You will also apply within a certain amount of days for the loan, and you will get loan approval within a certain specified time. If you don't get that loan approval, here's the new part of the contract. If you don't get that loan approval, let's say we said 30 days, within 30 days, the seller can cancel the contract up to 3 days after that 30-day period. Again, that 30 days is a number that you put in there. I'm just using that as an example. But if nobody cancels the contract, then after that 30 days, it is assumed that your loan is approved. So your escrow is now at risk because it's assumed that your loan is approved. Anytime up to that 30 days, you can say, hey, I couldn't get financing, and get your escrow back. However, all the other terms of the contract remain in place if the seller tries to get the escrow back. That's the way I'm reading this. And that means that they can keep your escrow, but you will have their house under contract until the closing date. So they can't actually get it until that time. So this is going to be a big point of controversy if you ask me, but that's how it basically lays out right now. You're basically going to go get your loan approval. You can waive your loan approval, but that section covers the loan approval. Next, we identify all the closing costs to be paid by the seller and all the closing costs to be paid by the buyer. These are not numbers. You get that from your lender, but these are the customary closing costs that you will incur. Find out from your lender or from your agent if you're selling what they will be. It says that you will issue title insurance, whether the seller or the buyer will pay and designate the closing agent. Each can have their own closing agent, or the seller can pay for it, or the buyer can pay for it. Typically, not typically, I shouldn't say that, but often the seller pays for it. It says that you will have a survey, and then whether or not you want a home warranty and who will be paying for that. You also have any special assessments, like here in Orlandia Heights, they went and they built roads, and they did special assessment for those roads. And they said, hey, city, if you'll pay for our roads, we'll pay you back with a special assessment tax, and as soon as it's paid off, that special assessment goes away. So you identify if you're going to take over the installments or if that's going to be paid in full. You have the various disclosures for radon gas, permits, mold, flood elevation, energy, lead-based paint, homeowners association, property tax, foreign investment, and seller's disclosure. Basically, it says that you should get all these disclosures if they apply to your particular case. Property maintenance is identified as the seller's job. However, the property is owned by the buyer the day of closing. There's a right to inspect clause. You can put however many days you want to inspect those things that were disclosed. There's also a walkthrough and re-inspection the day before the property is closed on, to make sure they didn't take all the appliances or whatever. And the seller, there's now a new clause in here that says the seller assistance and cooperation in closeout of building permits. So if the seller has a house, even if they didn't do the work, even if the person before them that they bought it from did the work and a permit wasn't pulled and there's an open permit, they will close it out. Typically they just have to go down and pay $400 or so and close that permit out. But they are saying that they will cooperate, and they will do that now in this new contract. There's also an assignment of repair and warranties. I'm not sure what that is. There's an escrow agent and broker. We identify who the escrow agent is. That's the one who holds the money and also does the closing. And there's a no professional advice clause, like I said in the very beginning of this, that we're not attorneys, so we're not accountants. If you need that service, go consult them. Don't ask us. We may have an opinion, but we certainly are not offering advice. There's a dispute and resolution paragraph for default and defining default by the buyer and default by the seller, as well as the resolution of those defaults. And then attorney's fees and costs are identified, who pays for what part. There are standards. These you start to really get into the legalese of this. But basically, they identify title evidence and restrictions. They identify that there will be a title exam to make sure that you can transfer clear title. There can be a survey if the lender or the buyer wants to have it done. That they will provide ingress and egress, meaning the seller will allow you to do all that stuff. They will provide you also any lease information. Any liens that are on the property are identified and will be satisfied. And time is of the essence, because everybody is depending on this. So there's a time is of the essence clause that says that everything will happen on time. Force majeure clause is moved to this later portion. They will convey the property and how it will be conveyed. They identify the locations of closing, the closing documents that will go through, the escrow closing procedure and how that money will transfer. Any prorations and credits, you will prorate taxes for the time that you live there, as well as things like any bills paid in advance, like garbage bills. And that they will allow access to the property again. There's another clause in that. There's also identifies the risk of loss and who is responsible for the loss. Typically it's the seller until the day of closing. A 1031 exchange, if you are an investor, is identified. And also the contract is not recordable. So you cannot record this contract. You record deeds, you do not record contracts. There's a bunch of integration and modification, meaning that if there's a modification done to this contract, it must be done in writing and as an addendum. We can't just agree on it verbally. There are waivers and restrictions on waivers. There are riders and addendums, typewritten and handwritten provisions, and there are collected balances, checks tendered, and things must be accounted for. Applicable law and venue, meaning that the state of Florida will dictate. And then there's your foreign investment tax. If you happen to be a foreign investor, it identifies that will be disclosed. Finally, there's a buyer waiver of claims, that buyer waives claims against the sellers and the agents. There are a list of potential addendums that could be included that you check, and there's an additional terms section. Often we put in the additional terms that the seller will pay a percentage of the closing costs, but just about anything can be identified in there. Every page has initials on the bottom, including the most important page, the signature page, has initials on the bottom as well, and we always forget that. You got to sign and initial it. The best way not to forget anything is to use, we use Authentisign, which is an electronic signature. That way you won't forget any signatures because they're all there, or it won't let you finish it. If you have any questions about a contract, or if you're interested in getting a contract for top dollar for your property, give us a call, shoot us a text, 386-866-1007. It is a seller's market, and it's a really good time to list your property. 386-866-1007.